Okay,
And I don't think anything's changed about the offer either.
okay.
You agree?
Great, Kim.
Right, it's the same offer, 30-year cap.
It looks like previously
It may have been,
to reduce the charge or to,
no, that's what they were requesting. That I do.
That was our counter.
not. Anyway, okay, can't read it.
My handwriting, I suspect.
All right, you're Ava Musgrove.
Yes, Your Honor.
And in clause number 25, DCCR 0048, Ms. Musgrove is charged with the first degree felony offense of murder. And that's from December 29th of 2024. And what that means, ma'am, and we've gone over this before, is that if you go to trial and you're found guilty, the range of punishment would be between.
In the murder case, the defense seeks flexibility. The judge doesn't budge. There will not be a plea agreement accepted after today. The warning is clear. Trial is next. No sympathy, no negotiation. The courtroom tone shifts. This decision changes everything.
Would depend on any information that was brought to me at a sentencing hearing. You have every right to reject that and have your case set for trial. I just want to make sure you understand possible consequences if we go to trial and what your options are. And do you understand all of that?
Yes, Your Honor.
And do you want to reject that offer and have your case set for trial?
Yes, Your Honor.
All right, and so based on kind of some of this back and forth, is there any reason to believe anything would change with regard to that offer?
No, Your Honor.
So I want to make everyone, make sure everybody's clear that there will not be a plea, this plea agreement will not be accepted after today. So it's either trial or a plea to something different unless there's some new evidence that's discovered that you guys don't have for some reason at this point. Do you understand?
Yes, Your Honor.
All right, and as far as you know, everything's, you have all the discovery and,
As far as I know.
okay,
of all the
any,
stuff,
you're not waiting on anything?
Not, I don't know of anything that's still out
Okay,
there.
we'll get it set on the next available trial docket. You can go back with the bailiff. Okay. Mr. Rojas, you have Marco Gomez. So on Gomez, hold on, it's a plea? Oh,
It was going to be, but then the victim called last minute and changed it. Decided she didn't want that. So
okay, so I can delete
You can
that
delete the paperwork.
registration. I didn't get the rest of it. I just got the registration.
yeah, you can see.
Good morning. Are you Marco Gomez? Speak up, please. And this is clause number 21-36-534. And Mr. Gomez is charged with sexual assault, set for trial to begin with jury selection on Monday, the 23rd. And what is the announcement?
Ready, state for.
All right, obviously, this is one of the oldest ones we've got, and so I would anticipate that it would be pretty high on the list, if not the top. Is there anything that you guys need me to know or we need to discuss before I number those cases today?
No,
All right, it looks like there was a previous rejection back in November. No changes or to that. That was for 15 years.
that was the offer we rejected, Judge. We had actually signed paperwork this morning for 8. After we signed it, I think the complaining witness called Mr. Smith and expressed that she did not want the 8-year offer. And so that was withdrawn. So
Okay.
we're here back at the trial docket.
All right, so then I'll set it. There won't be any plea agreements after today. Mr. Gomez, if you change your mind and want to enter a plea of guilty, it would be open to the court or to some other number other than that 15. Is that where y'all are at 15?
That's where we're at, Judge.
Okay, all right, then I'll set it and we'll probably see y'all at 1 o'clock on the 23rd. You can go back with the bailiff.
Judge, I have Willie Pugh.
Yeah.
Just need a reset on that. He's looking to hire in his own term.
Let's get Mr. Pugh, Willie Pugh. Willie Pugh.
Well.
Thank you, Judge, for fitting that detective.
Yeah, no problem.
Right, are you Willie Pugh?
Yes, ma'am.
And this is 25 DCCR 1835. Mr. Pugh's charged with unlawful possession of a firearm by a felon. Mr. Pugh, Mr. Rojas has let me know that you or your family are trying to hire a lawyer. Is that correct?
Yes.
So are you asking me to reset your case a little bit to let y'all do that?
Yes.
So what I'm gonna do is about a 30-day reset, which is a normal reset. If y'all get someone hired, they'll do the paperwork to substitute in. If for some reason you're unable to hire someone, Mr. Rojas is still your attorney, will remain on your case. And when we come back at that 30 days, if you haven't been able to get one, then we'll need to move forward with Mr. Rojas, okay?
Yes, ma'am.
All right, you can go back with the bailiff. Thank you, Mr. Rojas.
Thank you.
You've got Brian Trejo.
We've already taken
We
care of
already
it,
did that.
unless you want to reconsider.
Nope, I'm good. Thanks. Forgot. Oh, this Robert Lowe, we had him come back to do the registrations. I was wondering why that was here. Let me get those out of my queue to use. I don't think so. We just needed him here, I think. Who was his attorney? So that's good. Let's see, Mr. Salinas on Carlos Rodriguez.
Hold that for 1 second, let me ask this French.
Sure.
She's browsed out. Yeah. At least she was 8 minutes ago.
Mr. Wilkerson, Mr. Vasquez. Okay.
You swear.
Let's see, Mr. Gertz, you have Giovanni Coleman.
I do, Judge.
Giovanni Coleman.
Right.
Do you hear how relaxed it is in here? In Harris County, I'm usually thinking usually in Harris County, it's like, you show up if you want, you don't, but it's weird. It's like, really? Guess because I've been nice on it, maybe. So far, anyway. Good morning, you're Giovanni Coleman. And this is 25 DCCR 0479. Mr. Coleman's charged with murder. Mr. Gertz, what is the announcement?
Judge, we're gonna ask for one additional resetting. There's a number of reports and videos in this case that involves, I would say, pretty hyper-technical cell phone and block evidence. So block evidence is photographic evidence. Okay, sorry.
Thank you.
Sorry. Is this your first day?
It's not
my first day.
It's not my first day, but I appreciate that.
I apologize.
That's okay.
I'm so sorry. Either way, that a lot of the mapping and location and work that was done here just needs some additional review, in my opinion. And so, and then we were able to find very recently a ballistics report that was not labeled ballistics report. It was labeled like F-25 and didn't have any content. And so anyway.
So I'm gonna do one more. It looks like you have been on since May 2nd, so it's getting time for an announcement. I'll do another reset, but we need to see if we can get an announcement at that next court day.
Okay.
Okay.
Good. Thank you, Judge.
Stay in touch with He'll stay in touch with you.
She'll tell me.
See, you've got me thrown off
Yeah.
now. Ronald.
Wait till this next case.
Ronald Spites.
I need a couple minutes on that, Judge.
Okay.
I'm gonna be asking for more time on that. So if you want to call him out,
If, I mean, I can get it done if that's what you.
I can do that. I just need to talk to him too. So
Spites. We can ask him to keep them for a second after. It's me. Good morning, sir. You're Ronald Spites. This is 25 DCCR 0920. Mr. Spites is charged with manslaughter, and Mr. Gertz, what's the announcement?
Judge, we're asking the court for one additional resetting on this. I need to sit down with him and just haven't had a chance to talk in detail enough about the allegations here and the evidence that they have provided us, which I believe have downloaded everything that has been uploaded. So,
Okay. anything that you know of that you're waiting on? All right, so Mr. Spites, what I'm going to do is, now that Mr. Gertz has everything, he'll be out there, I'm sure, to go over all of the information and discovery that he's received. And then we'll see where we are at the next court date. Okay, thank you. Ms. Holmes?
Yes.
You got Tristan Calhoun for sentencing? And thank you for taking care of Mr. Lowe.
Yes, ma'am.
this morning also. Good morning, sir. You're Tristan Calhoun?
Yes.
And Mr. Calhoun was previously in court, entered pleas of guilty in cause numbers 25 DCCR 1216 and 1217. I've received the pre-sentence report as well as it looks like 2 memos from probation that were follow-ups to that report. Have you all had an opportunity to review all of that?
Yes, Your Honor.
Are there any additions or corrections to that pre-sentence report?
The only correction we had was, under the substance abuse history. I believe that they, on their alcohol date of birth usage, it should have been 18, 19 years old, not 8 or 9 years old.
Oh, okay.
Yes, ma'am, but that was the only correction.
Okay. Thank you. Anything?
Judge, I would just like the record to reflect that my office made multiple attempts via a regular victim contact letter with both of the complainants in these cases in order to try to obtain a restitution amount via that letter, via a restitution request form. I then was able to work with Miss Roach, who did some investigation on it. And we got an investigator to find different numbers for those young ladies. They were able to reach out to them and have them call to the probation department. As of this time, unless it's somewhere in the paper sphere, I don't have a restitution amount from them. I understand their concerns that they voiced, but I believe that the offer was appropriate based upon his lack of criminal history and the severity with which the court can punish him on any type of revocation. I don't know how Your Honor would feel about ISF based on his age, but I would suggest maybe at least considering the positive track of ISF.
And Your Honor, I have spoken with Mr. Calhoun in regards, I told him there could be restitution in the future if anything is provided.
Well, if it's
I-
not ordered today, there will not be any. And
Okay.
So that's why they attempt
Mhm.
to get all that information. And it sounds like the district attorney's office and the probation office has made a diligent attempt to try to get any number. And so there's no coming back later for restitution. So we'll just have to go forward without that. Mr. Calhoun, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. And in cause number 25, DCCR 1216, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney's office and defer all proceedings and place you on probation for 7 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. And I'll go over some of those in just a few minutes. And then in cause number 25, DCCR 1217, also find sufficient evidence to find you guilty. However, I'm going to follow that agreement and defer all proceedings and place you on probation for 7 years. You'll be ordered to pay a $500 fine in that case as well and to follow all of the rules and conditions of probation. I am going to order that you enter and successfully complete the JCDI program. It's an outpatient treatment program. That's what was recommended after that substance abuse assessment was done. I'm not going to order any further upfront or ISF. I think you're 28 or 29.
28.
Okay. This seems very, very out of character for you. And this was a terrible day and what you did was terrible and affects at least one of these ladies has some significant issues and probably will forever based on this. But I mean, you have no criminal history, and so we're going to get you the help you need, and hopefully you can be successful on probation and not have any issues. So what that means is you don't have felony convictions on your record right now. And if you successfully complete these probations at the end, the case will be dismissed, both of them. You'll never have a felony conviction. So it's a great opportunity that you're getting today. The other side of that, and part of what Ms. Molfino was stating, is that if you violate any condition of your probation, you can be brought back into court. And then I could find you guilty of both of the offenses and sentence you to prison for between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
So I'm handing you in each of your cases, the trial court certifications that shows these were agreements that I followed. And so you have waived your right to appeal. Probation will talk to you before you leave the courtroom today. It's very important that the first thing you do when you are released is go to the probation office and make sure you get everything started and lined up with them.
Yes, ma'am.
All right, yes, ma'am.
Sorry, just if I may, so
Take
the
these.
record reflects and in the instance that anybody is observing. Of course, I would not hesitate at all to put those victims in contact with victims assistance for on victims compensation.
Yeah.
Based on these pleas, I think that would be an avenue that we can travel down, and that I don't want this to obstruct that, but I understand the restitution amount. I did not have support today.
Sure, and there are definitely some avenues, if they get in touch with the district attorney's office, that might could help them with some of that. Okay, thank you, Ms. Molfino. You can go back with the bailiff.
Thank you.
Yes,
Thank you.
all right, careful. James Watney. Okay.
No.
Let's just reset. We're gonna reset, Ms. Molfino, sorry, sorry, yelling at you. Tyree Hartley, let's just reset it a couple weeks though. Mr. Wilkerson is in trial. Yes, ma'am. Sorry, didn't mean to look up and yell at you. I should have looked up first.
I will send Ms. Holmes information regarding the co-defendant judge would probably be beneficial to settle at the same time.
Okay, thanks. Okay, are you James Watt? You're James Watney?
Yes, ma'am.
And Ms. Holmes, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Gwatney, in clause number 25 DCCR 0736, you're charged with a third-degree felony offense of failure to comply with sex offender registration requirements. And that's from March 5th of 2025. And how do you plead to that charge?
I guess guilty.
Well, there's no I guess. Either you did it or didn't do it. So are you guilty or not guilty?
Guilty.
Are you entering your plea of guilty freely and voluntarily? Answer out loud, please.
Yes.
Did anybody force you to plead guilty today?
No.
Okay. I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Gwatney is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences.
After pleading guilty, the defendant hesitates, I guess. The judge immediately shuts it down. No uncertainty allowed, no backtracking. The sentence is pronounced 2 years TDC, calm voice, no emotion. In this courtroom, once you admit guilt, the consequences are final.
You the trial court certification that shows that this was an agreement that I followed, so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff.
Can I ask you one question?
Sure.
Whenever I was brought back from Oklahoma, I had 6 months left on my 3-year sentence. They sentenced me to ISF until discharge. Why was this charge that is being brought up on me now not brought up on me while I was being incarcerated back in ISF for the last 6 months?
How would you think I would know that information? I have
Huh?
no idea. I have no idea. I mean,
I have gone over the time frame with him. From what he told me, the time frame that he was in ISF was after this case was filed.
yeah,
Case has been indicted over 6 months.
yeah.
Yeah, and
I don't
he-
know. I don't know why that didn't happen, sir. I'm not sure if it was
The
something.
charges were supposedly filed in June of 24. And I was arrested in 25.
These charges are from March of 2025, sir. And you
25.
just pled guilty to that and it's done. You got your 2 years. You can go back with the bailiff, okay?
Okay.
I don't know the answer to those questions. Mm-mm. That is, I'm still. be done with it. It is. I just missed my note. On camera. Okay. Oh, jeez. Mr. Lewis, okay, you've got Michael Murillo. Let me give me just a second on that one. It's gonna take a minute. Let me see if I've got something quick to take care of. Took care of that, took care of that. What about Joshua Smith?
We're gonna, I talked to Mr. Smith and we're gonna need a reset on him, Judge. We need to take out his criminal history.
Okay.
Compared to.
We're gonna reset Joshua Smith. I'll give y'all some time to get that checked on. Yeah. Okay, here we go with. I don't know if this one wouldn't be easier. 1, 2, 3, 4, 5, 6 indictments that I've got. I just think it would be easier probably if you start printing from the back, start printing from 15, 17, and I'll start printing from the top and then that song just came into my mind. We'll meet in the middle. But I will spare everyone from me actually singing it. I'll just sing it in my head. I know mine actually is I've noticeably different also. Okay, I just did 1078. What are you on? Oh, 79. Okay. Perfect. Look at us. Yeah, that's a noticeable difference. Michael Murillo. Yeah, I'll take it.
Judge on 0377,
Uh-huh.
I think I may have checked consecutive instead of.
On the,
They could be a shipment.
I'll double. It's
Okay.
That says more about.
77. Okay, so on. Got it. 6 total. All right, sir, you are Michael Murillo,
Yes, Your Honor.
and Mr. Lewis, will your client waive the formal reading of the indictment in each case?
He does.
Mr. Murillo, in clause number 25, DCCR 0377, you're charged with the state jail felony offense of fraudulent use or possession of a debit or credit card from October 16th of 2024. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
And then in clause number 25, DCCR 0378. Just a second. I'll just need my tablet to go faster. You're charged with the state jail felony offense of burglary of a building from January 23rd of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with? Speak up, please.
Yes, ma'am.
Thank you. In clause number 25, DCCR 1078, you're charged with the state jail felony offense of burglary of a building. And this is from March 27th of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
Clause number 25, DCCR 1079, you're charged with the state jail felony offense of burglary of a building. And that's from April 29th of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
And then in 25 DCCR 1516, you're also charged with the state jail felony offense of burglary of a building from April 30th of 2025. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
Finally, in clause number 25, DCCR 1517, you're charged with the third-degree felony offense of possession of a controlled substance from January 29th of 2025. The indictment alleges that you were previously, well, are we going on count one only? So the state's elected to proceed on that count only, which is that possession of third-degree felony from January 29th of 2025. And how do you plead to that charge?
Guilty.
And again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they've charged you with?
Yes, ma'am.
In all of these cases, I have here on the tablets documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Williams?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
state tenders number one in each case?
No objection, Judge.
It's amended in each case. Is there any evidence that Mr. Murillo is not competent?
No objection.
All right, sir, in all of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences.
There's 6 felony cases, one after another. Guilty findings are entered, 20 months here, 5 years there. Sentences run concurrently. The judge delivers each ruling without pause. No lectures, no drama, just structured punishment. When the record speaks this loudly, the sentence follows just as firmly.
Time that you've been in custody that the law gives you the right to receive. In cause number 25 DCCR 0378, you're charged, I find you guilty now of state jail felony offense of burglary of a building. Sentence you in accordance with your agreement to a term of 20 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 25 DCCR 1078, find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a building. Sentence you in accordance with your agreement to a term of 20 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Clause number 25 DCCR 1079, find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a building. Sentence you in accordance with your agreement to a term of 20 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 25 DCCR 1516, find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a building. Sentence you in accordance with your agreement to a term of 20 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25 DCCR 1517, find sufficient evidence to find you guilty, and at this time find you guilty of count 1 in that indictment of possession of a controlled substance. That. I did it a little bit on one.
The next part.
I know you already know it. Okay. Carlos Rodriguez, are y'all ready on that?
Morning.
Good morning. Okay. Good morning. You're Carlos Rodriguez?
Yes.
And so, Mr. Salinas
Yes, right.
has been here before, and we went through some motions, and I granted, I guess, an order for the investigator for Mr. Salinas and the investigator for the Assistant District Attorney's Office to get together at an appropriate time for that investigator to walk through, take pictures if necessary, not touch anything in that home. And is
Yes.
that why we're here today?
Yes, Your Honor. It has not been done as of today. I've sent multiple follow-up emails to Chloe. I understand that new district attorney.
Yes, Ms. French is new on this, so I'm
Yes.
sure she's gotten up to speed. Good morning and welcome.
Good morning, Judge. Thank you.
Yes, Your Honor, but I mean, I've made all good faith efforts. I've put the state in contact with my investigator, made diligent follow-ups throughout the last month. And it seems that the order has not been, carried out.
And Mr. Gertz, why are you here standing
I
in?
represent Loriana Solo Gomez, Judge, the homeowner of the
Okay,
home whose home is set to be searched, and I'm here to assert his Fourth Amendment rights not to have his home searched without.
well, it's not a search.
I-
I'm not allowing anyone to search anything. It's just a walkthrough to get the kind of the lay of the land of the house is my understanding. So I think there is a distinction with regard to that, and
It
go ahead.
be difficult, Judge, but I mean, the Fourth Amendment, there's no case law that makes such an exception for law enforcement or anybody to just walk through a home and start photographing stuff, and I absolutely object. This person has a Fourth Amendment right to be free from searches, and entering the home is a threshold search issue. And this court has ruled on that in lots of occasions. There's not some imminent threat, there's not some safety sweep. This is a fishing expedition for evidence in a case. And we're asking the government and another parties or a party to a case that my client's not a party to's lawyer's team to be able to enter his home without his permission. And your order specifically says he's got a right to assert his Fourth Amendment rights. I'm here asserting his Fourth Amendment rights.
Your Honor, if I may, the Fourth Amendment protects against unreasonable searches. Given the fact that there might be potential Brady evidence, again, my client is facing potentially up to 40 years in prison. So I think, while of course Mr. Laureano does have Fourth Amendment right, I'm not arguing that he doesn't. That's clearly balanced here. And I'm not the state of Texas, so I wouldn't be able to press charges or on anything that is found there.
Request a search warrant.
Yes.
Your Honor, may the state be heard on this matter? First, let me say that I've just, while we've been here, placed my hands on this file. This order came to my attention yesterday when an email was forwarded to me. And so I backtracked a bit to find out how this all occurred. And my initial concern is that the way the order is written, it does seem tantamount to a search warrant. And our CCP 106 says that no person shall be deprived of their right to remain free from seizure of their persons in their houses, their papers and possessions, from unreasonable seizures or searches. Not only was the state not given notice of the motion that was provided to the court in order to have an opportunity to have notice of what was being required or an opportunity to respond in writing.
Well, I think they were. I mean, we were here on this motion previously.
Yeah,
It went.
Kobe argued.
Yeah, there
very
was an
much
argument.
the same arguments that they're both making, both attorneys are making,
So
were made
so
back
here-
then.
here's, let's, everybody stop.
Yes, Your Honor.
Here's what we're gonna do. I'm going to hold the enforcement of the order at this time. I'm going to do some of my own research based on the objections that have now been lodged by the Assistant District Attorney as well as Mr. Gertz on behalf of the homeowner. What I would like is for everyone to do a short brief on the matter and get that to me within a week or so, and then I will make some type of ruling and we can come back and at that point, Mr. Gertz.
Judge, may I make a proposal as sort of an offer and compromise? If the defense would like, I could have my investigator, who's a former Texas Ranger, go and photograph each room in the home. And at the defense expense, it probably costs $300 total or something, but photograph each room in the home. And come back and give an affidavit saying these are true and accurate photographs, and we could do it as a business records affidavit, so it'd be admissible at trial. And that way there's no state incursion into my client's home, and there's no other incursion into my client's home. And yet it's a trustworthy source. You know who I'm talking about. And my investigator could come and give a sworn statement or whatever proving up the photographs as well.
Your Honor, it seems like we're just, the purpose of that would only be to delay. My initial,
Well, why,
my initial motion, Your Honor, was just my investigator at the defense's own expense. I didn't ask for the state's investigator. That was something we compromised on, so.
That's what I ordered so that the homeowner would have
Right.
that level of
Right.
comfort, which is one of the things that Mr. Hopper, but
Right.
why?
Which
so
I don't
hold on.
oppose. Yeah,
Look,
sorry. Your
If, if what you're going in for, which I said is not a search and not touching or moving anything, but just to visually inspect layout of the home, then
Honor. Yes.
why would there be any issue with allowing Officer Best to go in and take pictures, even potentially a video just of the lay of it, so that there would be, I would ask if he did that, pictures and a video. He could come in, swear, and then that would be the same thing that I was going to allow y'all to do. And that way there's not your people going in. If he's willing to offer that, I think that probably is sounds like a good compromise.
We could do it by the end of the week. We could just be just done with it.
Well, look, Your Honor, I don't, and I appreciate the council's suggestion. My only thing is, because we live in a world full of human beings. I'm not saying that I don't trust whoever their investigator is. It's just I don't see what the issue would be with allowing my
Fourth Amendment.
Sure, Your Honor, sure.
So if we're gonna avoid a Fourth Amendment issue and me getting mandamus or whatever could potentially happen if I force this issue, and there's an easy way around it where I'm potentially not gonna get in legal trouble, then I like that idea.
Okay.
And so I
And I'm
would.
not trying to get you in legal trouble, Judge. Just trying
So
to-
what I'm going to do at this time is I'm going to modify the order that I previously entered. And I'm going to take Mr. Gertz up on his, if you're willing, obviously, if you were going to pay your investigator to pay, I'll let y'all get together with the investigator who is a very trustworthy person. If he's a former ranger, he comes in and does stuff all the time for different attorneys on both sides of the table here in Jefferson County. So if you guys can get that taken care of, I'll let y'all visit, get that done. I want thorough video, so that somebody would know exactly how to potentially lay out a house, pictures of the rooms, every room, and a thorough video of the house. And if you guys are willing to do that, then I will modify the order that is what's going to take place and get that done within, I would say, 2 weeks. Okay.
Your Honor, I would concede to allowing, that ranger, but I would ask for a specific deadline within a week, just given that it's been.
Well, I just said 2 weeks, so we're gonna get it done within 2 weeks. It's already Tuesday.
Can we have it the 24th, just so I have there's like a concrete date? Your Honor.
I'll give you a date.
Thank you.
No, we're on the 10th.
Yes, ma'am.
Let's get it done by Friday, the 20th. Mr. Gertz, Friday, the 20th, that's the rest of this week and then all of next week. If you'll get that done
Yes, sir.
and that information. And what I would ask is if you would make that available to both Mr. Salinas as well as the Assistant District Attorney.
Yes,
That
sir.
way they both have any information so that if he's talking about something, she also has a copy of it. That would be great. All right. I'll make some notes. So what I'm going to do, well, yeah, I'm gonna make some notes. Do you have my signed copy? Give me that one. Yeah, that would be better. So what I'm going to do is make some modifications on that order, date it today, with what that order is that I just did, and I think that avoids all of those issues.
Your Honor, if I may.
Yes, ma'am.
I think it might be prudent to also order that there be no alterations to the home of Mr. Gart's client prior to
As of right now.
this being effective.
Sure. So I would ask Mr. I'll make that a part of the order. And here's the thing, I don't think I can really order them to do anything. They're not a party to this suit. And so I would ask that you please have your client cooperate
Yes.
with not making any changes of substantive. Obviously, they're going to live in the house, but no major changes before that's taken care of. If they would go along with that, that would be great. But I don't know that I really could order them to do so. But I will make these modifications and then we'll reset it. Probably what I'll do is about a 45-day reset instead of a 30. That gives you the time to get that information back and then to kind of all get on the same page and we'll see where we are at that point.
Thank you, Your Honor.
Okay, thank you. Thank you, Mr. Arch. Thank you, Mr. Salinas.
Thank you.